Welcome to Legal AF with Court Accountability Action on the Midas Touch Network. My name is Mike Sachs. I'm a senior advisor with Court Accountability Action. And today we are honored to be joined by a pair of judges from the Article 3 Coalition. We have Judge Robert B. Kugler and Judge Kathleen M. O'Malley. And they both are integral members of the Article 3 Coalition, which is out to ensure that we keep our eyes on judicial security, judicial independence, and the rule of law. Welcome to both of you for joining. We're a pleasure to have you. And we need to talk a little bit about judicial security right now. There's a bill pending in Congress called the MARSHALS Act that is out to ensure that judges in this particularly dangerous area and era get the security they need from threats that come from their daring to be judicially independent. Judge Kugler, you were an appointee of George W. Bush, and Judge O'Malley, you were an appointee of President Clinton and President Obama to the federal district and circuit courts, respectively. Tell me about the perspective you guys had from when you were on the bench versus what judges today who are currently active on the bench face.
Well, if you'd like, I'd start. Back when I started, which was many, many years ago, there were, of course, threats. And there were judges who, and I'm thinking of Judge Lefkoe in Chicago, whose husband and mother were murdered in her home while this assailant waited for her. So these kinds of things happen. I know I was the subject of threats, and I had to have protection from the Marshals Service for months and months and months. But today is different. The number of threats have increased exponentially. I think social media plays a role in this. And you got doxing, things of that nature. We've got these instances where pizzas are being delivered to judges who are ruling on these controversial cases. And the pizza is in the name of the deceased son of one of my former colleagues from New Jersey, Esther Salas, whose son was murdered and husband grievously wounded by an assailant a few years ago. There's no question in my mind that the danger to judges has increased. You just have to look at the statistics from the US Marshals Service and the number of threats that they're dealing with against judges. It's something that I think worries us all, and it's something that needs to stop.
And Judge O'Malley, how do we go about stopping this level of threat?
Yeah, well, I mean, first with the perspective of what it was like back in the good old days. I mean, the reality is things were very different then. I mean, even the nomination process was much more civilized and much easier to go through. In my case, Senators Metzenbaum and Hatch worked together to get my nomination through. And that's because they were colleagues who cared about each other as colleagues. And so everything was different. But when I had threats when I was at the district court, I knew that the marshals, the FBI, and the US Attorney's Office all had my back. In other words, I felt protected. People used to say, "Aren't you afraid?" And I would say, I'm so protected by all of these people who view it as their job to make sure that the district court judges are safe. Yes, it was when Judge Lefkoe, it wasn't until Judge Lefkoe's horrible circumstances where her family was murdered in her own home that I think people woke up and realized judges needed more in terms of protection. But in those instances, you either had threats that were coming from disgruntled civil litigants who often were unstable, or in my case, a criminal defendant who was just very unhappy with the fact that he'd gotten caught and was facing a huge sentence. You didn't have the kind of threats that the judges are facing today. And I think what's happening is that we have kind of a perfect storm of now we have the internet where people feel like they can say anything they want and be protected, where those reading what they read, is being said, believe everything that's being said, and we also have the problem that I think civic education is lacking. So we've actually have a very different era now. and a very different atmosphere. There's a lack of respect for the judiciary as a whole.
How much do
Can
you
I follow
think?
up?
Oh, sorry. Go ahead, Judge.
I agree. The source of the threats is much different. In our time, and in my case, the source of the threats had to do with a case, a very high-profile case I was involved in. The source of the threats now is not people involved in these litigations. The source of the threats is people who are reading about it and getting all fired up and angry about the outcome of these cases. People we don't know who they are.
And how much of that comes from the President of the United States? In other words, I remember when Obama made a comment about the Affordable Care Act cases coming before the Supreme Court and just saying he'll hope the justices will do the right thing. And there was a big blow up about how he was threatening them in their decision making when he was commenting on what he thought was the constitutional elements of the law. Whereas when you saw it a little bit with during the Muslim travel ban cases in the first Trump administration, but in this one, pretty quickly early out with Judge McConnell up in Rhode Island, putting a stop to the federal funding freezes that came out with the OMB memo early on in the second Trump administration. You saw people at the highest level of the administration, whether it's President Trump or Vice President J.D. Vance or Elon Musk, attacking the federal judge who dared say that this was an unlawful ultra vires action. So how much do you think also the political environment is supercharging what may have already been a pretty delicate area of security?
I love President Obama, obviously, because he appointed me to the Court of Appeals. But I do remember when he said that about the Affordable Care Act, what he said was it would be unprecedented for unelected judges to overturn something that a majority of Congress passed, which is absurd because that's exactly what the Constitution contemplates. But that was a one-off comment. It was not a personal attack on any particular judge. I actually take this back to the travel ban era from before President Obama or before President Biden. But the travel ban era, when in Washington State, Judge Robarts was brave enough, who was the Republican appointee, by the way, but was brave enough to say that that's not constitutional. And his entire family was attacked. I mean, because that's when the play on the internet was really starting to build. And I do think that the overlay of the politicians being willing to say things about judges personally, as opposed to, I don't like the law or I don't like the way the law takes us. Because at least in my experience, I've never met a judge, Republican or Democrat, who didn't believe their job was to follow the law. So when you have politicians of either ilk who are willing to say that the judges somehow are inept or not real judges or are corrupt just because they are ruling on the cases before them, that's when I think everything started to change.
I don't think there's any doubt that our political leaders are stoking the anger that's felt out there. And the administration has certainly been in the forefront of this, but there are others also. I mean, we had situations here in New Jersey with the governor and a federal judge, and I'm sure it's true all over the country that way. But the political leaders are the ones who are setting the tone for these kinds of things. And that's where I think we can be most effective in hopefully getting this to stop and to lowering the temperature a little bit.
Yeah, and it seems to me that the federal district judges, at least at this moment, have been at the forefront of all the decisions from this administration's spate of executive actions that have been pushing the boundaries of legality. And so in what I think has been a bipartisan project of Republican and Democratic appointed federal district judges saying about 60% of the cases before them, go no further. You might like this cannot continue on this particular policy. That exposes federal judges to a maelstrom of disgruntled, hyper-partisan, people caught up in this moment. So how do you when you speak to current sitting judges who are receiving these cases, what do you say to them? What if they're wondering, how do I proceed knowing that these types of attacks will come from my standing up for the rule of law? Do you sense any trepidation? Do you sense any worry? Do you sense any fear coming from those currently sitting on the bench receiving these cases?
I do not. When you become a judge, part of your oath says that you will decide cases without fear or favor. And people take that seriously. And I think the judges who are currently serving understand, what the threats environment is out there, understand that if they get involved in one of these controversial cases, it's going to unleash a torrent of hatred and criticism, the likes of which I never saw when I was handling controversial cases. But I'm assured and I'm sure that they're going to do their jobs regardless. And they're not going to be intimidated by this stuff because that's who they are and that's what they do.
I think the framers really believed that it was important to make sure that judges were not afraid to do their jobs. That's why you can't reduce a judicial salary in term. But my concern is that as brave as all these federal judges are, there's some point at which it's not just a threat to them. I mean, people used to always ask me, aren't you afraid? And I'd say, well, that's the oath I took. So I'm stuck with it. But when the threats started to impact my children, my other family members, you have to think twice about why are we doing this job? I have never met a judge who says that they let those fears change their decision making. But at some point, you wonder whether or not that's the motivation, which is to try to get the judges not just to be afraid, but to change their decision and to inject a bias into the decision that the framers carefully tried to remove.
And gladly, I don't think we've seen any sign of that so far on the federal district court level. Let me switch gears and ask quickly about the Marshals Act. I'm not sure how familiar you are with the act pending in Congress right now, but it seeks to move the marshals from being within the executive branch to being administered under the judicial branch. I guess out of fear that this particular executive branch will not protect judges that rule against this administration's policies. What do you think about the prospect of moving the marshals under the judiciary? And two, do you think that's an apt concern that legislation should be addressing?
It's a bad idea.
Why is that?
Not just for the reasons you expressed about the fear that they won't protect judges. But judges have no business running a law enforcement agency under the Fourth Amendment and the Fifth Amendment. We don't know how to do it, and we shouldn't be the ones who are making the decisions. Because the marshals, remember, they do more than just protect judges. They enforce criminal laws, and they go out and make arrests and things like that. Judges should not be directing law enforcement how to make arrests, where to make arrests, when to make arrests. It's just a very bad idea.
Okay, this is where it gets interesting because I disagree. I think it's somewhat brilliant that the leadership of the federal judiciary has decided to go down this road. And the reason I do is that if you read the Marshals Enabling Act, their number one job is to protect federal judges. They only get to secondarily go after fugitives if there's extra time. They're really supposed to be protecting the judiciary. The fear is that because the current in the current climate, the belief is that the Attorney General will not allow the marshals to do that number one job, or will not fund the marshals properly, and there have been threats of that. So I think the belief is that if you put the Marshals Service under the judiciary and maybe fund that separately as a different line item for the judiciary, but if you put it under the judiciary, then the Attorney General would not have the authority to direct the marshals away from their primary role, which is the protection of the judges. It's not that you couldn't have, that in terms of their actual law enforcement duties, it's not that there couldn't be a secondary reporting mechanism up through the Justice Department. But the question is, who will protect the funding of the marshals? Who will appoint ultimately, or the head of the Marshals Service? I think that those are things that the judiciary is only doing this out of fear. But also, I think it was very wise of them to look ahead and to see this coming.
And it seems as though I think the Marshals Service was actually created in the Judiciary Act of 1789 and was housed under the judiciary, and there it stayed until 1870 when it was moved to the newly created Department of Justice. So how does that impact the analysis, if at all? If once upon a time this was a service that was capable of being administered by the judiciary, but now we're in the modern era in which things are, the threats are bigger, the country's bigger, the administration's bigger. Does an originalist understanding of the Marshals Service really carry on to a justification legally for it at this point?
I believe it does. Obviously, I think Judge Kugler and I are going to disagree, but I believe it does. And I also believe we have a much more sophisticated administrative mechanism in the judiciary than we used to have. The federal judges were a lot of, back then, disparate people all over the country who had no ability to work together, to communicate together. The judiciary is now run through a very sophisticated system of judiciary committees with judges from all over the country who can participate, and who the ones who are most effective at being administrators get very active in the administration of the judiciary. So I think that to the extent, yes, law enforcement has changed, or what the marshals might have to worry about has changed, but so has the judiciary itself. It's far more sophisticated than it used to be.
So long as the number one duty of the Marshal Service under that statute remains the protection of judges and courthouses, I'm not terribly concerned about where this all ends up.
Yeah. Well, judges, I thank you for your time. I'd love to get a final word from each of you on what is your most pressing concern of this moment and why you joined the Article 3 Coalition. Judge Kugler?
Well, I joined the Article 3 Coalition because, frankly, the threats against judges. After I retired, I was concerned about the direction and the attack on judicial independence. But when it became personal against the judges, many of whom were my friends, I decided it was time for me to get involved and speak out about these threats. It's going to take a lot of civic education, which is what Judge O'Malley and I are involved with the Article 3 Coalition, to get the word out to people out there, to students and lawyers and community leaders, small communities, large communities, that this has to stop. It's just too important, the safety of judges, to let this continue on. And that's what we will continue to do.
Yeah, I think that for me, my biggest concern is the attack on the judiciary as an institution. Yes, I worry about my former colleagues and all of the judges who are facing these threats, but I think that those individual threats are really a collective attack on the judiciary as a whole. And I think that again, going back to the framers, there are three branches of government, and for good reason. The judiciary has to remain a check on, the majority, on the executive, on Congress, it has to be available for that purpose. And we keep chipping away at it. And the rest of the country doesn't seem to understand how dangerous that is.
Well, judges, Judge Kugler, Judge O'Malley, thank you for joining us for these past almost 20 minutes. It's been a fascinating conversation, and I hope to have you guys back. We can speak more here on the Legal AF channel with the Midas Touch Network. My name is Mike Sachs with Court Accountability Action. You can learn more about the Article 3 Coalition at the link below. And please hit that subscribe button. Keep coming back. We'll learn a lot. Great guests. Thanks for joining.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.